as long as you already have the oath from yesterday, this is a continuation, providing that you're still under oath. Have a seat. We'll submit the questions. Max, there you go. A lot easier. Here. All right. It is. Moving where we left off.
Thank you, Your Honor. And Your Honor, it's still permissible to remain seated today?
Pardon?
I can still remain seated today at the table? Okay. Thank you, Judge. Sergeant Lacroix, yesterday we left off, we were talking about your interview at the police department with Matthew Baker. Let's look at a little bit. Can you see the screen here?
I can.
Okay. Now, prior to this time, we saw yesterday that you had brought him the written statement form and asked him to write a written statement, and we can see that here on here. Let's look at the timestamp is 15:56:17 is where we're starting it, and this is states, for the record, this is State's Exhibit 3. Now, yesterday when defense counsel was asking you about Mr. Baker going to the door and trying to open or knocking on the door later on in the interview, you referenced one other time that he had, or that you know of, that he went to the door. Is this the time you were referring to?
It is.
Okay. And so, as you can see in the video, is that the written statement that you gave him to fill out?
It appears to be. The only other piece of paper with a clipboard that I can think that he was actually handed.
Okay. And at this point, had he already written his statement?
Yes.
At this point, had you already concluded your interview with him?
I have.
And based on him going to the door and trying to open it, is this the first time that he realized that the door was locked?
I believe so, yes.
And prior to giving him the written statement, when the two of you were sitting in the room together and you were interviewing him, was that door locked?
No.
Prior to after you interviewed him and you left the room to go get the written statement form and a pen for him, during that period of time was the door locked?
No.
And then when is the first time that you locked the door?
After I handed him the witness statement form and the clipboard and made sure that he had what he needed to get that done, when I exited the room there and closed the door, that's when I locked the door.
And then after he wrote his statement in this video, it's the first time that he approaches the door to open it? Let's talk a little bit about your discussion with other officers at the police department who were not involved in this case. You mentioned that there were some other officers that didn't participate in this investigation. Do you recall saying that?
I do.
Okay. So therefore, were those officers apprised or aware of what was going on with Mr. Baker's status, as far as whether he was detained, in custody, under arrest, any of those things?
No, they knew as far as what type of crime we were investigating, but as far as Mr. Baker's status or what his level in this investigation was, no. They just knew that we had some interview room that we were interviewing that was, I guess you say, connected or involved or had information, however you want to word that, with this incident we were investigating.
During the time that you were with Matthew Baker, at any point did he ask to leave?
No.
Did you ever tell him that he couldn't leave?
No.
When you were speaking to him in his driveway and at his house, at that area, did you tell him he had to come up and talk to you, or did you ask him if he would come up, that he had information that you wanted to get?
I did not tell him that he had to come with me.
Going to Paramount Approach?
Yes.
Sergeant Lacroix, I'm going to show you Defendant's Exhibit 3 and State's Exhibit 4. Those are Mr. Baker's handwritten statements. Do you recognize those?
I do.
Okay, those have been previously admitted. You were talking yesterday about, on Defense Exhibit 3, the portions at the bottom that were for department use only.
Uh-huh.
Okay. You see those on Defense Exhibit 3?
I do.
And those same portions that for department use only, that is also on State's Exhibit 4. Is it just blank on State's Exhibit 4?
It is.
Okay. So is it safe to say that State's Exhibit 4 is what Mr. Baker handed you after he, or handed to Detective DeVito after he filled out the statement form?
It is.
Okay. So with regards to Defense Exhibit 3, the portions that have the date, the time, your badge number, your name, the case number, and particularly the portion that has it checked off as he is a suspect, was Mr. Baker given a form with that information filled out on it?
No, that information was filled in later within the investigation.
Okay. And so at the time that he gave his verbal statement, did you ever tell him he was a suspect?
No.
At the time that he did his written statement, did you tell him or write in any way that he was a suspect?
No.
So when he filled out State's Exhibit 3 and State's Exhibit 4, at that point, he had not been made aware in any way, shape, or form that he was a suspect?
No.
And that press release that was Defense Exhibit 4, can I approach again, Your Honor?
Sure.
Detective Lacroix, when did you draft this? And I don't mean an exact date and time, but was it after Jacob Koski and then Matthew Baker had been arrested?
It was after everyone that had been charged. It was after they had been charged and taken to jail and booked, and at some point, well after all the interviews had taken place.
Okay. And so by 10 o'clock in the the fourth line, where it says, by 10 a.m., both suspects plus an additional 3 persons had been detained.
Yes.
See that line? Okay. When police went to Matthew Baker's home on that morning, he was initially detained at around 10 a.m. Is that correct?
It was by the initial responding officers.
And then was he later released from that detention?
He was.
And then did he freely agree to come back to the police department with you to talk to you about what he knew?
He did.
And in the interim, from him agreeing to come back to the police department and prior to you interviewing him, in that gap in between, is that when you spoke to Jacob Koski?
It is.
Defense referenced yesterday something that Jacob Koski's sister Jude said. Do you recall that?
I do.
That if she had to guess, that it would be Matt Baker that was with him?
Correct.
Okay. At the time that she said that, had that information in any way been verified?
No. We were operating with that as it's like a presumptive statement, like you're putting a name out there as far as a possibility, so it's something we need to look into, but it's not been verified at any point. It's a normal statement we get with any type of crime, like as a regular burglary. So I said, I think Timmy down the street's the one that broke into my house, but they don't have anything as far as behind it. So it's from our end of it to try to find information to either verify or get rid of as far as that information. She provided that name as far as a possibility. So from there, we're looking to see, to try to either verify or disprove her statement from that point.
And was it during your interview with Matthew Baker that you verified that he was, in fact, the person with Jacob Koski in the house?
We did.
So he himself is who verified that information.
He did.
And is it after that that after you spoke to your command staff and put together everything from all the interviews, from all of the investigation, is that when you decided to seek an arrest warrant for Matthew Baker?
It is.
Now, going to the end in State's Exhibit 3, towards the end of the video, when the sheriff's deputy came in to place Mr. Baker into custody, you recall seeing that on video?
I do.
And just to be clear, for the record, you were not in the room at that time?
That's correct.
Did you have any conversation with that deputy that we see here? Let me... Pause it here for one moment before we get to the deputy. Yesterday you testified about Mr. Baker being under that blanket in the corner of the video.
Yes.
At some point, had he requested a blanket?
I believe so, yes. One of the, I believe it was Detective Sergeant Bender, opened the door, provided him with a blanket.
Okay, this deputy that's coming in the room, had you at any point briefed this deputy and told him about your interview with Matthew Baker?
I did not.
Had you at any point briefed him and told him about your interaction with him in the driveway?
I did not.
To your knowledge, did this deputy have any idea what was going on with this case other than he was there to place Matthew Baker under arrest?
I did not. I was tasked to another part of the investigation, was told they would, by my supervisors, they would contact someone as far as to handle the transport. So that is over. I had no conversation, nothing as far as related to me to this, directly from me to this deputy about what was going on.
Okay. So when he asked another detective if Matthew Baker was Miranda's, he didn't know anything about the circumstances leading up to his arrest.
He did not.
He didn't know anything about the fact that he had not been in custody and Miranda was not required.
Judge, I'm going to object at this point. Ms. Benito has repeatedly said things like, he doesn't know if Mr. Baker's in custody or detention. At this point, I just want to make sure that I am clear that that's a legal determination, and this officer can testify to, was Mr. Baker in handcuffs, things like that. But at this point, it's just been said too many times, I have to object to asking for legal conclusions such as, was he detained, was he in custody, was he freely there, things like that, Your Honor.
Yeah, this is a generalized objection for this last question. I mean, the generalized objection to all, there were other questions like that previous to this one. There was no objection. And I was wondering when you were going to stand up.
That's correct, Judge. I'm not here to interrupt, and I want the court to be able to hear what it is that the officer says, right? But when it has been over the course of the now 3 days worth of testimony, it has reached a level where I have to object, and I have to let the court know that I am not conceding that Mr. Baker was not in detention, and that this is a legal determination that the court has to make, and that it is at best the opinion of the officers whether or not he was in detention. It is at best the opinion of the officers whether he was there freely or whether he was coerced or anything like that. It's just been, it has crossed a line, Judge, where my concern over the impact of those lines of questioning has exceeded my desire to not unnecessarily interrupt, someone's direct examination.
Well, I thought we were headed down to confirm, at least that this officer on the witness stand had no conversation with the sheriff's deputy about the status of Matthew Baker. And he didn't really preface the last question with what he told the officer. He doesn't know what somebody else may have told him, unless that officer's here to testify. So I don't know if he could even say whether he did or didn't know, because he doesn't know what the guy was told unless he talked to him, and then he can't testify to what he said. So I just clarification for the record, he can only testify about any communication he had with the sheriff's deputy unless that deputy's here to testify and or someone else had a conversation and that deputy's here to testify and that other officer. So in fact, what you're saying, you had no conversation with the sheriff's deputy, you could be somebody who's gonna come and look.
That's correct.
You didn't know who the sheriff's department was send.
That's right.
You didn't call and ask for some particular officer.
I did not.
You did not have a conversation with the officer in the picture before you entered the room about any of the status of Mr. Baker.
I did not.
Did you tell him what room he was in or somebody else did?
Imagine somebody else did.
You weren't even in the location.
I was tasked in a different area handling something else with the investigations. I was back in my investigator role, not involved in this side of it.
All right, thank you. That helped clarify the issue.
Thank you, Judge.
Thank you, Judge. Sergeant Lacroix, the officer, the detective that this deputy asks, was he Mirandized? Was that detective involved at all in this investigation?
No.
So did that detective, to your knowledge, have any knowledge about whether or not Mr. Baker came up there freely and voluntarily?
Again, Judge, I'm going to object as to whether or not he doesn't know what that officer knows. I think that this officer can testify to, did he tell that detective whether he was Mirandized, but I don't think he can testify to whether or not that officer knows anything. He can only testify to what it is that he said or what he communicated.
Why don't you limit your question to what this testifying witness sergeant told any of the officers in that video that are there with that sheriff's deputy?
Well, Judge, I think he can testify, which is why I put it in the form of to your knowledge. Does this detective who is leading this deputy into the room, to your knowledge, was that officer detective involved in the case at all?
He's already testified to that. That wasn't her objection.
But then my next question, I'm sorry, Judge, I didn't mean to interrupt.
Go ahead.
But then my next question was, to your knowledge, now that we've indicated that he was not involved, to your knowledge, does he know anything about Matthew Baker coming up there freely and voluntarily? I think he can answer that to his knowledge, whether or not he knows.
That would only knowledge that they would acquire from the other officer. And that officer not here to testify about what his knowledge was, where he did. As I understood, there are many people involved in this investigation.
Yes, Your Honor.
While this officer that's in that picture was not involved, that doesn't mean he didn't have a conversation with somebody else. But this officer here, this witness, might not have a clue who he had a conversation with, and now, if somebody told him, oh yeah, he knew what was going on, well, that's hearsay.
Well, Judge, with information shared between officers, collective knowledge of officers does come in.
But before he's testified, that officer was not involved in this investigation. Do you have any idea what the officer knew about this investigation at all at the time he's going in that room?
I can only speculate as far as from what's being talked about from those that were in the peripherals as far as for helping. I didn't tell him specifically about what was going on. I know word had gotten out to the department as far as what we were dealing with, but I can't say what he was told because I didn't tell him anything directly for myself.
Concerning Mr. Baker, his possible role in any of what was going on?
Correct.
Okay. All right.
Thank you, Judge. Yes, Judge, thank you. At any point in your speaking to Matthew Baker, either in the driveway or at the police department, at any point, did you tell him that he had to speak to you?
I did not.
At any point, did you threaten him in any way if he didn't speak to you?
I did not.
At any point, did you promise anything if he spoke to you?
I did not.
And in fact, at some point during your conversation with him at the police department, did he express to you any concerns about what would happen or his safety with regards to talking to you and what Jacob Koski might do that put him in any kind of concern for his safety?
It did toward the end of the interview. He expressed his concern, I guess, asking if we could provide as far as protection for his concern for himself, and saying we could possibly sort of retaliatory action from Mr. Koski or any of his friends based off his statement that was given to me.
And was your discussion at that point talking about basically his safety after he left the police department and went home?
I explained to him what options that I would be able to provide. I knew that we couldn't do 24-hour security because we're still in a police department. Advised him we could do, place his house on patrol or a watch list and things as far as we could do from our end of it to make sure that he and his family were safe. I absolutely let him know that he didn't have to worry about Mr. Koski because I had Mr. Koski secure, but understood his concern about other friends or people that Mr. Koski, as far as that was associated with, but provided like an outline what I was able to provide to try to help assuage those fears of retaliation.
And so based on your conversation with him at that point, and I'm going to pull it up here in 1 moment. Based on your conversation with him, did he seem to indicate that it was his understanding that he'd be going home and that's why he was asking you these questions?
That's correct.
Let's talk a little bit about that.
So again, we're excited what you saw with them. You can say, let me go get some safety forms for you. I'll give you the information that you need as far as how to fill out the time card, which is your basic information, and I'll give you as much time as you need to fill out everything.
I just really don't want any more trouble to come. I'm not saying trouble, I'm just saying like for him, like if he just goes out or something, I just
I apologize.
yeah.
Like, it's not like misdemeanor weed charge or just rule of thumb. You don't just bond out for that like that.
But it's true.
I'm fully aware of the sister situation, because that's my case too.
Okay.
I got her on that too. That one was a little bit different on the aspect of, fortunately, nobody got it. But that one was, the family put themselves in a bit of a financial strain to get her out. And it wasn't like it was going to be easy. She was in there for a while. The other two people that were with her are still in there.
Yeah.
It's just, it's not.
I didn't know if he had money like that to get himself.
There's not that many people around here that got money like that. Yeah, if he gets charged for stuff like this, there's not that many people walking around and got enough money to try to get out on multiple homicides.
He knows a lot of things.
But he knows somebody that's holding the bank. I mean, they bank.
And he tell my address.
Well, again, understand, I can't make any sort of promises that that won't happen. All I can tell you is, understand, in this way people down this, there are people out here in the world that are just looking to prey on people regardless. For whatever reason. happened, it could be you walk on the street, car runs up on you, Jackson could be in there, Jackson could be shooting with your wallet, phone, watch, whatever. Just be cognizant about what's around you. See, don't walk around with your head down.
Sergeant Lacroix, you're talking about him being cognizant of what's around him and don't walk around with your head down. Was that discussion in reference to him after he left the police department and was out living his life at his home?
Yes.
Stuff like that. We can do things as far as how to keep your house, people watching your house, so nobody comes by and tries to shoot in the house or breaking in the house or something like that. But again, from your aspect of it as well, with you, your mother, and your sister with her child there.
That's only concern is my sister, because my sister stayed with her, so with the baby. A lot of times.
So I'm saying, that's one of the things we can do more as just to kind of be a presence, keep all that mess from happening. Again, I can, all day long I can sit there if I thought we would tell him, hey, look, nobody got to go over towards the Baker's house. That's just me telling him that. He can decide to listen to their cops live. But, just understand, I'm not going to place you out to a position to where you're knowingly in harm's way. Like I said, throwing your name out there, you told me this, you told me that, you said this, you did that. I'm not going to do that to you. I'm going to go back and tell people what other people told me. I don't put people's names in the street because it don't work like that. I'll start doing that and nobody's ever going to talk to me. So a lot of times I find people who are doing this like this, I gotta have people talk to me. Because I'm not going to put you in any sort of hard way. I throw your name out there. Plaster your logo, plaster your picture all over this room. Whenever I get him in here, he sees your picture and I start pointing. He told me this, I'm going to do that now. Unless you go and start telling people what you said.
I'm not.
And
I can't talk about it.
So I'm saying, unless you start going around with what you said, I'm not going to go around with what you said. The only way I'm going to find out is if you say something.
So Sergeant Lacroix, during your discussion with him throughout this interview, was there ever a time that you gave any indication that did you ever say to him that you were going to arrest him?
I did not.
Did you ever say to him that you were going to seek a warrant for his arrest?
I did not.
Did you ever tell him that he was a prime suspect and he couldn't leave?
I did not.
Did you ever tell him that he was being detained for any reason?
I did not.
Your Honor, may I have 1 moment? Thank you. Your Honor, that's all the questions I have.
All right, any further call?
Just very briefly, sir, you didn't tell Mr. Baker that he was a suspect. Is that your testimony?
That's correct.
Did you tell him, but you also didn't tell him that Mr. Koski had implicated him as an accomplice in a quadruple homicide, right?
I did not tell him that either.
But you wrote that in your report, right?
I did.
And after having an interview with Jacob Koski, where in your words he had implicated Mr. Baker as an accomplice in a quadruple homicide, the next thing that you say to Mr. Baker is, "You're not under arrest yet." Is that right? Is that what you told Mr. Baker? You were asked on direct about whether or not whether or not the door was locked when Mr. Baker completed the written form? And you said that it was, right?
When he completed the actual statement? When he
Yes.
completed the statement form, to my knowledge, the door was still locked. I had not been there to unlock it after I locked it when I left the room.
But you had locked it earlier when you gave him the blank form.
That is correct.
Okay. So the door was actually locked, whether Mr. Baker knew it or not, the door was actually locked when he was handed the blank form, correct?
When upon leaving the room, when I handed the blank form, that is correct.
Gotcha. I don't have any further questions for you this morning. Thank you, officer. Thank you, Detective.
I do, Your Honor, thank you. Just one question. Detective Lacroix, defense counsel just asked you if the words that you said to Matthew Baker were, "You're not under arrest yet." Those actually weren't the words that you said, were they?
I don't believe so. I don't remember as far as verbatim. I believe it was, "You're not being charged with anything at the moment," or "You're not being charged, I'm just looking for information."
All right,
Something along those lines.
All right, let's go back to State's Exhibit 3 and we'll play that portion.
So what's up again, so you're supposed to take a look? Over at the TV. Well, basically, but everybody's business, stuff has been going on that happened over in Lockton Gap that involved Coffee and all this other mess. Understanding with the moment not being charged with anything, we're just trying to get information. All right.
As was, at the moment, you're not being charged with anything, I'm just looking for information.
All right. That's all the questions I have, Judge.
No further cross, Judge.
All right. This witness is just now. Thank you.
And these, you,
And there's another witness out there, I believe.
Yes, Your Honor, that's not the State's witness.
Oh, it's not your witness.
Nope.
Okay.
State has no further, I've decided I'm not gonna call any further witnesses
Okay.
today, Judge. Thank you. State rest.
Your Honor, the defense calls Jennifer Green. And Mr. Sudelska is going to get her.
All right. Right up here, the witness stand there. Take your mask off. Raise your right hand. You solemnly swear the evidence you're about to give in the matter of coming before this court, with the truth, all truth, and nothing but the truth, so help you God, and be so affirmed.
I do.
State your name for the record,
Jennifer Green,
and by whom you employed currently,
the Cobb County Police Department.
and I think that's all I need to know.
Thank you. I want to make sure that I am using the correct term. Would it be Officer Green?
No, ma'am.
How would I refer to you?
Ms. Green.
Ms. Green? Okay. Ms. Green, how are you currently employed?
Right now I work with the Cobb County Police Department in the Latent Prints section.
And in 2016, how were you employed?
2016 I was with Henry County Police Department in the crime scene unit.
And would that have been true in October of 2016?
Yes.
And what were your responsibilities in the crime scene investigation unit?
In the crime scene unit in Henry County, we go out to various crime scenes, process them as far as photographs, videos, sketches, whatever is needed, collect evidence, process for fingerprints, package evidence. We would also not just do the original crime scene, but follow-ups as well, if they have any search warrants or need photographs of people. And we also examine latent prints.
In October of 2016, what types of evidence were you trained or certified to collect?
Was I trained or certified to collect? We would collect DNA evidence, we would swab for DNA. Basically anything we could collect and put in a bag if we thought it would go to a lab for them to do specialty testing on, we were able to collect. We collect gunshot residue, latent print evidence, DNA evidence, ballistic evidence, all that stuff.
When you mentioned latent print evidence, that's different from taking major case prints, right?
Collecting latent print evidence is different from major case prints, yes.
In October of 2016, were you trained or certified to take major case prints?
Yes, ma'am.
Were you at any point on October 27th, 2016, asked to report to the Henry County Police Headquarters?
Yes.
And do you recall about what time your assistance was requested?
Yeah, I don't know what time it was requested, but I arrived at 12.
Yeah. Okay. And when you arrived, did you have an occasion to have any interactions with Mr. Matthew Baker?
Yes.
And what were those interactions?
I was requested to take photographs, a GSR kit, and major case prints.
Did you do those things?
Yes.
And when you did those things, where did you do those things?
It was at headquarters.
Was it in an area of headquarters that was secured or unsecured?
There were 5 people that were there that I was requested to take photos, and they were kind of spaced out all over the place. So some people were in a conference room, someone was in an interview room, there was also someone who was in, there were these little rooms off of a hallway.
Do you remember whether or not when you took, and when you were there, did you take major case prints from Mr. Baker?
Yes.
And did you take a gunshot residue test from Mr. Baker?
Yes.
And did you photograph Mr. Baker?
Yes.
Okay. And those items, they were put into evidence, were they?
Yeah, the major case prints goes with the latent print file, which is in the crime scene unit because we do the comparisons. The gunshot residue is packaged to go to the GBI and goes to the property room. And photographs are burned to a CD to the property room as well.
Okay. When you encountered Mr. Baker that day, was he with another officer?
There was an officer sitting, I believe, in the hallway right outside the room.
Okay. Do you recall whether or not there was, do you recall the name of the officer that was sitting with him?
That I do not.
Do you recall whether it was more than one officer or just the one?
I don't recall.
Do you recall seeing Mr. Baker walking around the headquarters unescorted? Do you recall that at any point?
No.
And you never handcuffed Mr. Baker, did you?
No.
And when you interacted with him, he didn't have handcuffs on at that time, did he?
No.
And you didn't conduct an interview with Mr. Baker or anything like that, did you?
No.
For the clarification for the record and for the judge, what are major case prints?
Major case prints are just the recording of all the friction ridge detail on the skin. So your palms, your fingers, the tips of your fingers, the sides of your palms, basically anything that we can compare.
And when somebody is formally arrested, do you take major case prints from them at that time? Or are major case prints taken from them at that time?
No.
No. Can you explain the difference between major case prints and the fingerprinting that happens at the time of an arrest?
Normally when they get arrested at the jail, they just do a basic fingerprint card, which is just the rolled prints and the slack prints, and then they'll do a palm, which is just that. When we do major case prints, we'll do it from victims, from anybody that we need that might have touched an item, because when we process for items, we get latent prints, which are fragmented fingerprints. It could be this tip area, it could be the side area. We very rarely get like a really good whole print. So we need to make sure we cover all ground and take all of the areas of friction-rich skin. Since we know we're doing the comparison, we have it all.
So when you take major case prints, are you taking more of the fingerprint than you do in the fingerprint cards?
Yes.
So you have more information on a major case print?
Yes.
When you took the major case prints from Mr. Baker, did you tell him anything about this is only to exclude you from as a suspect? Did you say anything like that to him?
I don't recall. I could have. A lot of times with major case prints, I say, we do take major case prints, but it is just to say yes or no. Is that your fingerprint? Is that not your fingerprint? But I don't recall whether I said that or not.
One way or the other, right? And Mr. Baker wasn't the only set of major case prints that you took that day, right?
That's correct.
Did you take major case prints from Jacob Kowski that day?
Yes.
And you said that you arrived around noon.
Yes.
Do you have, to the best of your memory, how soon after noon did you take the prints and gunshot residue and photographs of Mr. Baker?
I don't have the specific time in my notes. The GSR kit will have the exact time it was taken on the actual kit. So if I could see that evidence, I would know exactly when it was taken. I know when I arrived at headquarters, I did the 2 females first, and then Kowski, and then Baker, and then the other guy, Jake Williams. So I did go in that order. But it would only be me guessing for what time it would be, and I would give probably a good time frame in there, because I assume I would have done photographs, GSR major case per person, and then move on to the next one. I did have someone who was in training assist me with the 2 females, so that might have sped up the process as well. And again, I cannot recall exactly if they might have said, hey, can you do this GSR kit first because they have to use the restroom or something. That's a possibility. So unless I have that physical evidence, I can't tell you the exact time.
I definitely understand. To help narrow down that time frame, would it have been within a few hours?
Yeah, I would probably say everything would have been done probably by 3:30, 3:34.
So to the best of your recollection, somewhere between 3:30 and 4 would have been when you were done with everybody.
We're all 5 people.
Okay. If I may have the moment, Your Honor. I do have just 1 or 2 more questions. So, to the best of your estimate, how long does it take to photograph, take major prints, and do a gunshot residue test per person? Just an estimate.
In like a perfect scenario, like the first roll print is fabulous, like 30 minutes. But a lot of times when we take major case prints, people tend to move. It's like we have to do several of them to get them done. Keep in mind I had someone with me training, so it might have taken a little bit longer. So I would say 30 to 45 minutes.
Okay.
Yeah.
But you know that you took that evidence from Mr. Baker prior to 8 or 9 o'clock that night, right?
Oh, yeah.
Okay. When you were done with, and we'll limit it to Mr. Baker, when you were done taking the gunshot residue test, the major prints, and the photographs of Mr. Baker, did you return him to the officer that had been escorting him?
So the officers don't leave us because we are civilian. We're not sworn. We don't carry weapons. We don't have any powers to do anything. If someone runs, I'm just gonna be like, all right, bye, you know?
Okay.
So an officer sits with us or is right outside the room.
Okay.
So I don't return anybody. I'm just done and I go about my way.
Because nobody's ever handed over to you. They're always with an officer. Is that a fair statement?
There's an officer nearby, yeah.
Okay. I don't believe that I have any more questions for you. Thank you.
Thank you, Judge. Ms. Green.
Yes.
Hello. Let's talk a little bit about, you do these, taking pictures, doing major prints, and doing gunshot residue. You do those on victims?
You can, yes.
Okay. And not just you can, you have.
I have, yeah.
And you do those on witnesses in a case?
Occasionally, yeah.
Okay.
Major case prints quite often, GSR kits sometimes, and photographs a lot.
Okay. So, and you do it with suspects as well?
Yes.
Okay. So the fact that a person has these, is there at the police department and has major case prints done, has a gunshot residue test done, and has photographs of themselves taken, that has nothing to do with whether or not the person is a suspect.
Right.
Correct. That has nothing to do with whether or not the person is arrested, correct?
That's correct.
That has nothing to do with whether or not the person is free to leave the police department.
That's correct.
That has nothing to do with whether or not the person has been detained by officers.
That's correct.
Okay, because sometimes victims in a case, they may have been near where somebody shot a gun and they might have gunshot residue on their hands.
That's correct.
Okay, and sometimes witnesses in a case, same thing.
Yes.
And sometimes witnesses in a case may have touched something at a scene that you all need to eliminate their prints from.
That's correct.
And sometimes victims themselves may have touched something at a scene, that you might need to eliminate their prints from.
That's correct.
And certainly sometimes suspects may have touched something at a scene that you need to eliminate their prints from.
That's correct.
Okay. And so when you take these prints, it has nothing to do with whether or not this person is believed to have committed a crime.
Right.
Now, when you arrived at the police department around 12 o'clock, you started the process with Kayla Head. She was the first person that you came in contact with?
Yes.
Okay, and you took photographs of her general appearance?
Yes.
Both close-up and mid-range, right?
Right.
You took pictures of her face, palms, back of her hands, bottom of her shoes, and a broken fingernail on her right middle finger?
Yes.
Okay, so you got kind of detailed with the photos.
Correct.
Okay. And you also collected a gunshot residue kit.
Investigator Jackson did, but I was with her. Yeah.
With her, and that's who you were training at the time?
Yes.
Okay. And so when I say you, I'm going to refer to both of you.
Okay.
I mean the collective you. Okay. And then you also collected major case prints from her.
Yes.
And you were talking a little bit before about major case prints and how they differ from the prints from somebody who is being arrested and booked in.
Correct.
Okay. To be clear, you do the major case prints. Somebody else, when somebody is being booked into the jail, that's who does their rolled prints and their arrest prints.
That's correct.
You don't do those.
I do those.
You don't work for the jail.
No.
You don't work for the sheriff's department.
No.
So when somebody's arrested and they're getting fingerprinted by being arrested, you have nothing to do with that process.
That's correct.
So after you did this with Ms. Head, you went ahead and the second person that the two of you went to, you and Investigator Jackson, was Brooke Knight.
Yes.
Is that correct? Okay. And same thing as with Kayla Head, you took overall photos of her general appearance,
Yes.
and you took mid-range photos and close-up photos.
Yes.
And again, you did her face, palm, back of her hands. She had a tattoo on one of her fingers, or two of her fingers.
Yes.
Okay. And you took some other photos of tattoos and things of that nature.
Yes.
You also collected a gunshot residue kit, or
Yes.
Investigator Jackson did.
Yes.
And Investigator Jackson assisted you in collecting major case prints.
Yes.
Okay. And so you did that with both of these young ladies, right?
Yes.
And at the time, did you know whether or not they were victims, witnesses, or suspects?
I don't know.
Okay. When you met with them, was there a police officer near or outside the room with each of them, as you described earlier when defense counsel was asking you questions?
Yes, it should have been.
And is that, again, pretty standard every time that you're involved? Because as you said earlier, you're a civilian and not law enforcement.
Yes.
And so that is even done when somebody is a victim in a case, because you could have a volatile victim who, even though they are legitimately a victim, but they might lose it and become aggressive or violent towards you.
That's correct.
And so that is done as a precaution for your safety, no matter who the person or what their status is as a victim, witness, or suspect.
Yes.
Okay. After you took that information and those photos from Brooke Knight, you then moved on to Jacob Koski.
Yes.
Okay. You took overall photos of Mr. Koski.
Yes.
You took close-up photos of his face, palms, back of his hands, tattoos that he had.
Yes.
Okay. And he had a cut, looks like on a finger.
Yes.
Okay. So you took basically the same type of photos that you had taken, pretty extensive photos that you had taken with Miss Head and Miss Knight.
Right.
Okay. You also collected a gunshot residue kit from him.
Yes.
And it looks like you collected a pair of shoes from him that had suspected blood on them.
Yes.
And you also collected major prints from him.
Yes.
And then the fourth person you went to was Matthew Baker.
Yes.
Okay. And you said that Mr. Baker was in a room. Was the door to the room that he was in, was there a door closed, or he was in an open room?
It was, when I was there, it was open.
Okay. You went to Mr. Baker. You took overall photos of him showing his general appearance.
Yes.
You took close-up photos of his face, palms, back of his hands, shoes, and bottom of his shoes.
Yes.
Basically just like you had with Kayla Head, Brooke Knight, and Jacob Koski.
Yes.
Did you collect a gunshot residue kit?
Yes.
And did you collect major prints from him as well?
Yes.
Okay. And at that point, did you have any idea what his status was, whether he was victim, witness, or suspect, or arrested person?
No.
Okay. And then you went on to Jacob Williams?
Yes.
And you did the same thing with Jacob Williams. You took overall photographs of his general appearance.
Yes.
You took close-up photos of his face, palms, back of his hands, shoes, and bottom of his shoes.
Yes.
Same process that you had just done for the other four.
Yes.
Did you also collect a gunshot residue kit from him?
Yes.
And did you collect major prints from him?
Yes.
Okay. Did you have any idea whether he or any of these folks were suspect, victim, or witness in a case?
No.
And you said it's pretty customary for you to tell somebody that when you're taking their prints, it's just to say if yes or no their fingerprint shows up on any of the evidence?
Yeah, because when I'm taking major case prints, the easiest way to get major case prints is for people to be comfortable. And fingerprints are great because they're just facts. You either touched it or you didn't. So if you didn't touch it, it's great to get fingerprints. And I like people to be comfortable and relaxed and know I'm just here to take it to show evidence. So.
And when defense counsel asked you if you took major case prints from Mr. Koski, you said yes? Is that correct? You
I took major case.
Okay. But you also took them from the other 3 people that were there as well?
Yes.
And so the process that you went through with Mr. Baker is the same process that you went through with these other 4 folks?
Yeah, I mean, we have standard processes. When we do photographs, they're all standard. When we do gunshot residue kits, it's standard. Major case prints are all standard. It's just a procedure we follow. So regardless of what case you look at, it's all going to be the same.
And you said earlier that in a perfect scenario, it might take 30 minutes, but if you have to redo things, it might take up to 45 minutes.
And that's just a guesstimate too.
Okay. Yeah. And a guesstimate meaning, and I don't want to put words in your mouth, but could you have a situation where it only takes 20 minutes?
Could, yeah.
Could you have a situation where it takes an hour?
Yeah.
So there is really a pretty wide range of time possibilities that it takes.
Yes.
All right. But the thing that you are certain about is this is the order that you went in
Yes.
with these individuals.
Yes.
And this is, you took basically the same information, meaning the photographs, the gunshot residue kit, and the major case prints. You took that from each of these individuals.
That's correct.
And you said earlier that you don't return anybody to an officer. So how does it end then? Once you've collected your information, you just leave?
Yeah.
Okay.
I'll leave. I'll tell who's ever outside I'm done. And that's it.
Okay. And you indicated earlier when defense counsel asked you that you didn't see Matthew Baker just kind of freely walking around the police department.
I didn't, but when I'm there, I went to my people, did my stuff. I'm not hanging out. I'm not in the hallway hanging out, so I'll go back to our office when I'm done to take the evidence back.
Okay. And typically, within that back portion, when people come in the front lobby of the police department, the Henry County Police Department, that's open to the public. But typically when someone is brought back through that locked door and they are escorted back there, typically somebody is going to be escorted back there. People aren't generally just freely roaming around back there.
That's correct.
And that's been your experience there?
Yes.
So it was nothing unusual not to see Matthew Baker just walking around and milling about freely and randomly in the police department.
Sorry, say that one more time.
Say it again?
Say that
Sure.
one more time.
So the fact that you didn't see Matthew Baker freely roaming the halls of the police department, that's not anything unusual.
Right.
You didn't see Kayla Head freely roaming around the police department.
Right.
You didn't see Brooke Knight freely roaming around the police department.
Right.
You didn't see Jacob Williams freely roaming around the police department.
Right.
And you didn't see Jacob Koski freely roaming around the police department.
Right.
In your experience, do people, not just these 5 people, but victims and witnesses in the case, do they generally just freely roam about the police department, or are they typically always going to be escorted or near an officer because it is a locked, secured area?
Yeah. Yes.
That's all the questions I have, Jeff.
Yes, did you collect any items with suspected blood on them from Mr. Matthew Baker?
No.
I don't have any other questions, Your Honor.
I think I know the answer, but I got a couple of questions before I make sure I'm clear. And talking about this specific major case, prints, gunshot residue, photographs, etc., on this October 27th, 2016, how long have you been employed with Henry County in this capacity?
I have been employed with Henry County. I started Henry County in 2012. I'm prior to Henry County, I had worked at crime scene in DeKalb County starting in 2006.
Okay, so you have been in this business since 2006, either Henry County or DeKalb.
Yes.
Okay, so as of October 27th, you had at least up to 2016 tenure experience.
Yes.
Do you have a normal, I guess I call it a modus operandi, with Henry County, in this particular situation? Do you go and set up shop in one room and everybody comes in one at a time? Do you do all that, or do you go where they are?
I go where they are.
And that's the way you always do it?
Yes.
Okay. So some time has to be taken up for somebody to take you where they are.
Well, they don't generally will take me there.
Okay.
People will be there and they'll say, hey, this person is in this conference room, this person's over here in this room, this person's in this room, and I know where those rooms are because it's not that big, so I can just walk to the next one.
All right, so that's not going to take up a lot of time, knowing where to go for the next one. But you did say that you did the two females first. I assume that was intentionally. You know,
I have no idea.
and wouldn't necessarily keep a note of that.
I don't remember, no.
Okay.
Yeah.
And assuming everyone has the same number of fingers, palms, it takes about the same amount of time to do the fingerprinting. And as long as they're steady and not rolling and shifting, smudging.
Yeah, you gotta, I mean, because different people's hands leave prints better than others. Some people would leave crystal clear prints, other people, it's very hard to see, smudgy, you might have to use some kind of ridge enhancer to do it. So there's a lot that goes into taking legible major case prints, so.
All of these individuals had the same test done, except for, I think, possibly when you mentioned blood, or possibility of blood or shoe.
Right.
You know for a fact you were gone by 4 o'clock, is that right?
Yeah, it would have been, trying to think, yeah, but I leave work at about 5, I believe, so I was out on a normal day.
And, if you had left at 3:30, you spent approximately 42 minutes per person. It could have been longer on one and shorter on the other, but on average.
Yeah.
That's all I got. Y'all have any more questions?
I do have one question based off of the court's questions about your modus operandi, your usual procedures. You had said that it was part of your usual procedure to explain to people about how they're not necessarily a suspect when you take major prints. Did I have that right?
I don't say that's like a usual procedure. I often will just tell people, we're taking major case prints, you know, these are good to exclude or include you. All it's doing is saying, did you touch this item? Did you not touch this item? Were you here? Were you not here? And I do that just to calm people down because, you know, people get very nervous when giving major case prints and there's so much to getting major case prints. I want them to be at ease.
So here's my specific question. Do you recall whether or not you made that statement specifically to Mr. Baker on October 27th, 2016? Do you recall?
I don't recall specifically.
And do you recall whether or not you made that statement to Mr. Jacob Kosky on October 27th, 2016?
I don't recall specifically. I did.
I'm gonna have one moment, Your Honor. I don't have any other questions. Thank you, Judge.
No other questions, Your Honor?
You can step in and get excused. Thank you. All right, is that witnesses?
I have no further witnesses, Your Honor.
All right, probably have some questions I need to ask y'all before we start whatever's the next step. We have some motions that have been filed, and I'll ask questions about other than what we've been dealing with. But right now, we'll stick with what we just finished up today and ask your preferences. First, I am going to need a copy of whatever's been admitted as far as the D3, D4, your interviews. Now, when I do just a demo type of hearing, I like to look at every word that's said. Interaction, you never know what's going to be on there, because playing and a notice, you turn the volume down, it's helpful. But then when you get it really way up, it's just the words can get blurred, which helps. But I have the leisure time, and the senior judge and other judges don't have it. I can actually read all the stuff and watch everything. But if you have specific areas that you want to look at on a video, that is helpful too. What I usually do is I don't go back and look at the whole thing until I look at the specific. The reason for that is I want to see what you believe I need to focus on it. And if you're a team, this is over here, and the state's got, inevitably there's always something I find that is helpful to me, but I'm not looking at the whole thing. It's pretty boring. That's the way life is. Secondly, as of today, we have a motion that requires some sort of argument. Closing argument. If you want to do it in writing, I'm not against that. I think it's much more focused. If you want to have a verbal today, we'll take it. And supplement it with a written brief, close, a brief. I'm good with that. If you just say, look, I want to submit a written brief, I can be more concise and focused. I'm good with that too. Whatever y'all want to do. If you want to just 5 or 10 minutes a day, but you're going to cite law. If you're going to cite law, clear the brief. But I'm going to spend all my time now that I have my computer ready. I've got my laptop updated. I can access the county files. I can do a lot of things from home. But I'm going to probably have to have some software to play the videos, and I'll get Tim to take care of that. So,
Judge, I apologize. I think that the player is actually on what you would have, so I don't know that you would need any additional player.
If it's a DVD, I'm going to have a DVD drive, because I don't know if the new laptop don't come with one. You got to buy one.
Oh, okay.
Plug in. Now, the old laptop will have a DVD drive. Mine does not. I guess I'm even fairly turn them up to have to go buy one. Only $50. Something like that. And I'll get whatever I need. But I want to hear from y'all what you want to do. Some sort of verbal today. It's 11:20. And then do the supplement by brief, the time frames for getting that done. I know y'all have schedules. But I know trial and death in the case of December of any year. I just never heard of stuff. It could happen. Now that we have to survive COVID, we're trying to get back. We're trying to, on Valentine's Day. Who knows what we're doing, but really, you want to go first on that?
Yeah, Judge, my preference would be for us to do an oral argument today and then supplement. Then that way, if there's anything that, based on the questions the court may have, I can provide law. If there's things that the state raises, then we can address those. If there's things that we raise, the state can address those. So I think oral argument with brief briefing would be the best way to get the information to the court.
All right.
And Judge, for the state, I was prepared to do oral argument today. However, if we're going to have to brief it anyway, then if I got to write it down anyway, I guess I would prefer to just do a written brief then and have us cite where we want the court to look, the case law we want. But I'm open to doing either. But if we're going to write a brief for, it just seems like it would be repetitive.
For me, it's the brief mostly for the citations of law and case law, things of that nature. So that I can still look at it myself and read it. You don't have to provide a copy today. I'm not going to read it today. You don't have to go put it on stack with you. But if you have copies and you want to do the verbal, I'll I'll do a little bit of brief verbal today, that's what the state wants, that's what the defense wants. But I believe that would mean for the state seldom, in my humble opinion, has ever surrendered the playing field and said, okay, I'm not gonna do it on oral code even if the defense does. They never can stay seated. They cannot be stuck to that chair. They're going to pop up and say at least 2 words. That's all.
And today would not be any different, Judge.
I don't know y'all that well, but I know the sides well enough. That's usually what will happen. So we will have a verbal today, as much as you want to make it. Don't worry about me picking up your citation, because I expect you to cover that in your brief.
Yes.
I'm not gonna write those down, but I may make a note of some issue that you, but I think it's pretty clear what the issue is in both the statements at the scene, the Baker home, and the interview at the meeting. You know what the issues are, and just, it shouldn't take long for that. The statement of waive opening reserve closing.
Yes, Your Honor, I would prefer to do that. May I ask one other question?
Yes.
When would you want the written briefs? The only reason I ask is because I may be in trial next week with Judge Miranda. I don't know that, but I might be.
I had a new trial motion with Mr. West last Friday, and I knew he had a murder case coming up, and I said, you pick the day. I don't know what y'all's schedule is, y'all, they're busy, y'all are busy. Hey, just pick a date. If you've got a verbal ready to go, you won't take long to get free.
Yeah, Judge, Mr. Sadowski and I are in trial in January. I don't want to rush Miss Venuto. I wouldn't want to be rushed myself, so we don't want to rush Miss Venuto. And so we would just ask maybe Miss Venuto can let us know when she would be ready, and then we would, because I assume that you would file the opening brief, and then we would reply to that.
All right, well, let me give you my schedule, because I will not be reading anything other than the trial I'm on, which would be November 29th through December 3rd, Monday through Friday. Expect to take 4 weeks there on that case. If you can get it in before Thanksgiving, wonderful. If not, I would like to have it Monday, December the 6th. If that's enough time. But I think it is.
I was just asking for it not to be next week because I might be in trial. That's plenty of time. And Judge, would we both just be submitting them to the court, or would it be that the state files the initial brief and then the defense has the opportunity to respond to the state's brief? When we are doing closing arguments, state always gets the last word, so I would ask not to do it that way, that we both submit them. That's what I would ask for.
And so I would, if you prefer this, I have no problem with this. November 22nd is a Monday, that's the week of Thanksgiving. If you get it in by that time, that gives me, based on my schedule for this Thanksgiving, I'm not having to do a whole lot, which is a surprise to me, but I'm not unhappy about it.
That's fine with me, Judge. I can get it in by then. I was just hoping you weren't going to say next week. That's really all I was hoping for.
Next week won't do me much good either.
Judge, December 6th is good for the defense.
Either way, it's probably going to be in December before I can get a ruling out, but I've got so many days available, and nobody wants to take my dates in December because of too close to Christmas. So December 6th, get it to me by 5 o'clock. That's it. Everybody has my email. And I will, everybody needs to get me whatever exhibits you have, copies and duplicates, so that I can have them. I know you have those. And that's, you can either leave them, probably not mail them. You can mail them here. I have a box downstairs. Everything comes to that. I don't get much mail here, thank you. That'd be fine if you send it out.
You want us to? Judge, our office is in the courthouse. I could
This
deliver it
is,
somewhere.
I'll briefly Judge Merrill's case, and you can leave it with Lynn if you want to. Ms. Chambers is an administrative assistant, going to be in the building. State's going to be in the building, they can drop it off. If y'all want to mail it to me, that's fine. I'm going to look at it like I both of them in the briefs and anyway. Okay, so I think it's wasting my time to look at it before the briefs. We'll do you good, I'll be looking at something that's alone. I know how it is, but I don't know what I need to be focused on. So I wanna wait for the focus, although I will have something to do. And then we need to talk about, are there any other motions that the defense has filed that they need to have hearings on? Well, I'm looking at a motion for the court reporter to take the notes to be made a part of the record. Motion to narrow the issue, October 15th for both of those this year. And motion for an order requiring the district attorney to respond in writing to each motion which is contested by the state. As I say, otherwise they were all filed on October 15th. Motion to clear the members of the police department, members of the law enforcement sitting in the courtroom in uniform. Motion for a transcript. Motion for an order requiring the state to elect between malice murder and felony murder. Motion to disclose the past and present relationship association between the district attorney and Inspector Gerard to disclose records. These look like they're gonna need another day just to go through how many we have.
Yes, Judge. And Judge, for the record, we've actually already done all of those motions. We did those last, I want to say September or October of 2020 under the different case number. Those are the ones that the defense has refused to allow to be part of the record, but the court has already ruled on all of those. So we would ask that that ruling stand.
So you have them under the 217, 73 case number?
Yes, Your Honor. They're under the old case number. We did those, and I'd have to go back and look at my notes to get you the exact date. But if you recall, we did all of those virtually. I just don't remember the date off the top of my head, Judge.
Well, on the other two informed me that they have not made it into this file, and I have, so I'll get that pulled and get copies, so that I'll have copies of what has been filed by the defense and copies of what was provided to by the state. And before the brief gets in, it's probably be good to let me know by email if any of these motions you believe on the defense side require a hearing with witnesses or just simply a hearing without witnesses. If you think you have to have a hearing where you can have argument on it, it's fine. Well, I don't know, I haven't read any of them.
And what I can tell you, Judge, is based off of my memory of what was filed and on that October date, we will need to have hearings on all of those motions. I know that we have heard previous motions under the previous amendment that had not been adopted as part of this record. I mean, if the case had not been re-indicted, we would not have to have these re-hearings, but we do. Out of all of those that have been filed, Judge, I believe that there is only one that would be an evidentiary hearing. Everything else would just be argument. And I don't have the number of the motion in front of me that's evidentiary. That's.
I don't think these have any numbers on them anyway.
They should all be numbered in the top right corner.
8,
Or
21, 25, 18, 15. I'm assuming that's 25, maybe. No, there's a 31, so it goes on up. 33, maybe the highest. 118, so we go to 118. You can shoot me an email. What you have, we
Yes,
don't use the time we have today for the close.
yes, Judge.
But, obviously, January would be out for you guys, because we have a trial. I suspect y'all starting to line back up or crank back up with trial. Bad news for me is I don't have a courtroom. Fourth judge will be sitting here sometime January 1 or 2. And, we won't have this option of using this courtroom except when it's not being used for some other purpose. Which means all the other courtrooms will be available, starting with Judge Merrill, since it was formed in this case. I'll try to use his courtroom first, on the down days we may have. I don't even know if have they published a calendar yet, for 2022?
I think they have, Judge. What I know for a fact is that the entire month of February is reserved for trials for all 4 judges for the entire month. So 4 weeks of trial then.
If you give me one moment, I can
I will
see
meet
if they
with
publish.
Chief Judge about what he wants me to do. We have 5 courtrooms in state court, so we might get access to the road, but also they have been cranking up and doing a lot of trials also. I'm sure that at some point we would find space, because this will take priority, and then may have to just make space available. I don't think it'll take more than a day to do evidentiary hearing, unless you tell me otherwise. I don't know how many witnesses you can have.
I would imagine that we could probably get that done in a day, but that's going to be I would imagine that to be a full day.
I don't have a problem with that.
That's fine, Your Honor. January through June of 2022 has been published, Your Honor. It's a 6-month calendar.
Okay, we haven't won the whole year. I will get a copy of it. 2 weeks ago, they didn't have it, I don't think, but and I didn't know, they don't share that with me unless I ask for it. All right,
It just came out on Monday, Your Honor.
okay, good. All right, well, let's proceed with our closing that needs to be done today.
Judge, would you mind if we were a request for just a brief 5-minute break?
I had no problem, I should have reported that.
And then, Judge, I believe that we can just power through the rest of it. We have these closing arguments that we have to do. We have a brief ex parte. I don't think it'll take us very long, but we do have a request for a 5-minute break.
How about 10?
Okay.
It'll take at least 10, I think.
Your Honor, and considering if we're going to just power through, are we gonna break it up and stop for lunch, or we're just gonna completely finish it then?
I don't know how long y'all will talk.
Okay,
It's not a show, it's information to be provided to the court that's not already been provided, or just to remind the court of what was provided. I'm not a novice at this, I've heard hundreds of these books, hundreds of them anyway. And I know what the issue is in this case, I'm pretty sure. And you just need to move as quickly as you can, but if you're gonna tell me you're gonna take 2 hours, I'm like, we're gonna break it up. If you're gonna take 30 minutes each, we're gonna finish before we break for it. That's way I planned it.
okay.
Well, I left it with my wife this morning. If you don't see me walk through the door 10 after 12, that means I'm trying to push through lunch.
Understood.
And Judge, do you want, if we have cases for the court today, do you want us to present those to you, the actual hard copies?
Yes,
Okay, thank you.
that would make it a little easier. Take a 10-minute break. Everybody can do what they need to do.
Just to help the court with the CD issue, I'm fine if either you or us put it on a USB.
I actually have a USB.
And then, yeah, to
They
make
came
that.
up with one, but I have to put, I have to put the others on here, so I have this one already. No, I'm sorry, this on USB, and I can put these on there.
I'm not at all insisting that they're on CDs or anything, whatever is easiest for everyone.
Is that what you're going to do, to copy it for him to do?
Not today, but I will.
Right, so you're gonna hold on to these.
You and I I don't wanna hold you up but you and I can talk about how we.
Just let me know where the exhibits end up.
Yeah.
That's all I need to know. Thank you.
You said we have 10 minutes, right?
Yes. Maybe a little longer if you've got.
That was my understanding.
Thank you. 10 minutes.
Oh, yeah.
It's called a
I'm just gonna move this here for closing.
Sure.
Free so people can get moved so much.
Yes, he got around there.
He got out there on there too. That was a good move, wasn't it? Perfect years that we made it about. So I don't see that happening. Just reading about something this weekend. It's not worth it. Their weeks is about strength.
suggestion about this, if you want it.
I'm sorry?
I have a suggestion about.
Can we talk about it after we do the argument?
Sure.
Just want to get my stuff together, thank you.
Yep.
Okay.
I'm not trying to exclude anybody else, I'm not trying to take anybody else out of the. Sure, and then if you're ready,
Is everybody ready?
I'm ready.
What time have you done, break 10 minutes yet?
11, no, we went on break at 11:38, and it's only at 3:40. So they have 4 more minutes.
That was mine, was persuaded. It's easy.
Okay, I'll watch it, 11:45. I hope we have the letter they called me and said, you got it all. I said, okay. Oh, I had calls, and you all catch my calls, but it's nothing. Well, they have a rapid test that, that can be done somehow. I don't know how that's done. They do the brain probe with me, so. And he rushed it as much as he could. Because I said if I test positive, I need to find somebody to replace me. He said, and he just said, we're gonna assume you don't, because you're not showing any symptoms of it, no fever, none of the other junk that goes along with it, so. Yeah. Yeah. You know, it didn't me either. That's why I thought, it's finally caught up with me, because we had a little change in the weather. And, but. Yeah. Well, I just wanted to be careful.
That's good.
But I had a physician last week at 5 o'clock. And every single person brought their small children, because there were 15 toddlers running around. And I was just saying, just stay away from me.
All right. Thanks for time.
Yes, it has.
Start our closing, so let's come to order.
Everybody come to order.
Thank
Come
you.
to order.
Everybody should be back, they want to come back. They gotta watch. All right.
Judge,
Yes?
small request, when you're
Yes.
speaking, some of the folks in the gallery still can't hear you sometimes.
Well, I'm not turning this on until I speak.
Okay.
When we have the videos playing, I'm afraid I'll get some feedback or something, I'll just turn it off. It should be on now, we're not playing any videos, but hopefully we won't be. But, I can't talk anymore than this microphone will allow me.
Oh, that was it.
Well, I said, I'm not gonna be the one doing all the talking, you can remind me when I start talking. How about that?
Sounds good.
And I believe the stated waive is opening, reserve is closing. So that puts the defense up first.
Yes, Judge. I'm gonna borrow the, audio. Judge, I'm going to do my best to quickly make my way through the law portions of this and keep myself limited to the facts because we're going to provide briefs to the court. But this is my closing argument here for the Jackson Denner hearing in Mr. Baker's case. Just briefly, the court knows what the law is, that Miranda rights are required if somebody is in police custody and that law enforcement asks questions that are reasonably calculated to elicit an incriminating response. And we've talked about this a lot during our objections and questions and conversations with the court, but if somebody is not formally arrested, then the inquiry here is whether or not there is a restraint on freedom of movement to the degree associated with a formal arrest. And the test here is whether a reasonable person in the suspect situation would perceive that he was at liberty to terminate the interview and leave. And this is an objective test, and the state has correctly noted that a police officer's undisclosed suspicions about the person being questioned don't factor into the determination about whether or not a person is in custody. However, and this is something that we haven't talked about yet, however, if a officer's views are communicated by word or by deed, then they are relevant and they are part of the court's analysis of the totality of the circumstances that the court considers. But the other side to this coin, Your Honor, is what we have in State versus Abbott, which is that an officer's motivations for their safety or the safety of others do not speak to whether or not a reasonable person would feel that they were free to go. In other words, simply because there are measures that are taken that are for safety reasons, that does not mean that a reasonable person would not have felt that they were in custody or not free to leave. And so, Judge, and this will be in the brief, there are a number of factors that the U.S. Supreme Court has given us to consider, and some of them include how long the questioning is, statements that are made during this interview, the presence or absence of restraints, and things of that nature. All of them are at play in this case. Now, it is undisputed in this case that Mr. Baker was not read his Miranda rights. So that leaves for the court, with regards to the Miranda issue, and that leaves simply for the court to decide whether or not Mr. Baker was in custody at the time of either of these interviews. And we have, I want to just for a second focus the court on this point. The consideration about whether or not the statement was voluntary and freely given is separate from this Miranda question. We are not alleging, and we concede that there is no hope of benefit or fear of harm in this case. That's not what this statement issue is about. It is about whether he was in custody, and because the facts kind of overlap, the court would also, separate from that, have to make a determination as to whether or not that statement was voluntary. So, as you said, there are these two statements that we have there, the statements at the driveway and the statement at the police station. To the state's point, we have multiple things that Mr. Baker is saying in the driveway. I think that the court can consider all of those as one statement. And if there are portions that the court feels would be admissible or inadmissible, I think that that's fine. But for our purposes of this argument, we've got the statements that were made at the driveway at 3300 Highway 81, and then we've got the statements at the police station. The court knows the general time frame here. The incident occurred about 2 a.m. and it was Detective Lacroix was the one that responded to that, among many others. And actually, there's a slight misstatement here. It's not Detective Lacroix that does the interviews. There are other officers that are doing these interviews, but Detective Lacroix is apprised of what information the other detectives have gleaned from these interviews. But where this inquiry really begins is at 9:52 a.m. when Officer Frugoli locates that white Jeep Grand Cherokee on Highway 81. And then the units, as we've saw in the video and heard from multiple officers, a lot of these units arrive. There are weapons that are drawn. There are people that are ordered on the ground. People are handcuffed. And every single officer that has testified that was there when Officer Frugoli and the others had the individuals out of that Jeep has testified that Mr. Baker, Ms. Head, Ms. Knight, and Mr. Williams were all at least in their estimation at some point detained. And there's really no question about it. They were held at gunpoint, they were handcuffed. And they have all testified to that. They've also all testified that there was a very large police presence, that they were all armed, and that many of them were in uniform, and all of them arrive in police vehicles, whether they are marked or unmarked patrol cars. This here, Judge, is an excerpt from the CAG report. It kind of gives us, and this is part of the evidence, and the court can look at it to sort of get an idea of the timeline here. And I think that that is important in this case. And what we have here is, per the CAG report, it clearly establishes that by just before 10 a.m., we have everybody that was in that vehicle at gunpoint and detained. And this is backed up by the testimony of Officer Frugoli. And I have an excerpt up there from his testimony. He testified that he followed that vehicle out of the driveway, down Highway 81, onto another street, down a cul-de-sac, back on the Highway 81, and back into that driveway. He says twice in this little excerpt that he followed them. And then Officer Frugoli clearly testified that he had everybody out of that vehicle at gunpoint and on the ground. And he also testified that Officers Danielson and Padgett drew their firearms as well. Officer Danielson, one of those individuals, he testified, and he testified that in fact he did have people in handcuffs. And there's an important bit of Officer Danielson's testimony about why people were put in handcuffs. He says, so it was one of those deals that everybody gets secured, everybody gets put in handcuffs, and this is the important part, Judge, and we're going to sort everything out as soon as we can figure out who we're supposed to be talking to and who were not. So part of the reason that they are wanting to know where everybody is so they know where everyone that they want to interview is located. So the people that they want to talk to aren't wandering off. And then here is Officer Danielson clarifying what he means by securing people. He clarifies that people are handcuffed. Officer Paget, another one of the officers that was there in the at the initial detention, he testifies again, people at gunpoint and in handcuffs. Officer Phillips. Now, Officer Phillips' testimony is very important because he's the one that has that body-worn camera. He also testifies that there were individuals on the ground at gunpoint and in handcuffs. And Officer Bolton says the same thing. Upon my arrival, I think that the individuals that were inside or around the vehicle had been detained. And he says that 2 different times during his testimony. So, Judge, let's take a look at what that means. This is what being detained looks like. And what we have here for the record is we have a screen capture from Officer Phillips' body cam, and the court can look at that, and I would encourage the court to take a close look at that because it is actual objective evidence of what happened. So thank goodness that Officer Phillips had his body cam on and that he found that and was honest enough to bring that to everyone's attention. But what we have here is 5 people on the ground with at least 5 officers, because you see 4 on the video, plus Officer Phillips, who's the one with the camera. We've got 5 officers, all armed, one of them with a rifle, and we've got 5 people on the ground, Miss Head, Miss Knight, Mr. Baker, Miss Lemire, and Mr. Williams. And we see from the timestamp, we've got another screenshot up here, that Officer Phillips's body cam is consistent with what the CAD report says and what everyone's testimony is that these detentions began at 10 a.m. And here we can see, consistent with the testimony of the officers, again, that these individuals, where they were standing, where they were at, is being controlled by these police officers. They are moving Mr. Baker and everyone from the driveway out to Highway 81. So the size of the police presence at Highway 81 is very important. We had a number of officers testify, and we see it in the video, and a lot of these officers testified that, yeah, their recollection was correct and verified by the video. We have Officer Danielson saying that the entire traffic unit responded. Officer Phillips saying 15 to 20 officers. All of that testimony was verified by what we see in the video and what the officers testified to yesterday. This is an extremely large police response. And I want to be clear, my argument isn't that that's unreasonable. They were looking for somebody that they felt had, at that moment, killed 3 people, and there was another person fighting for their life. This was a very serious case, and they were looking for someone that they considered correctly to be very dangerous. So, of course, they have an extremely large police presence. So you can see how large that police presence is, and this is immediately after they have been detained westbound on Highway 81. We've got at least 4 police cars here. When you look up the other direction, I believe this is eastbound, we see 4 more police cars, and this is all at 10:01:51 per that timestamp. So within 2 minutes of them being held at gunpoint and handcuffed, you've got at least 8 police cars right here. A few minutes later, about 8 minutes later, what we have here is we have additional police cars arriving. You can see that in the video as it has a clear shot of what's happening down Highway 81 looking westbound. We see more police cars arriving. We also have the officers that testified yesterday verifying and pointing out that, yeah, they were some of the officers that arrived later. We also have Officer Gagnon here, and he is one of the ones that's arriving with an AR-15. So he has a rifle, and he's not the only one. This is a little bit later that morning after Mr. Baker had been temporarily unhandcuffed in order to go and save his dog from being shot by these police officers who were trying to secure the home. He has, there are 5 more officers, at least 5 more officers standing on the porch of the house. So the reason I put all of this out, Judge, is to show just how extremely large that police presence was, how they were on the highway, in the house, on the front porch of the house. So just walking through that timeline a little bit, Mr. Baker was escorted back into the home in order to secure his dog, so that, as the officer said, they didn't want to have to kill the dog. What we heard in that clip is the one officer giving Mr. Baker instructions. And they say, if he starts to bite one of us, we're going to kill him. Unquestioned, very clear. If they felt that they were threatened, they were going to shoot that dog. And he says, you got one shot at this. And then you see Mr. Baker he goes into the garage, picks up his dog, puts the dog into the laundry room, so the police don't kill it. And then, as soon as that's done, as they're walking out, Officer Phillips re-handcuffs Mr. Baker. And they all testified that Mr. Baker wasn't free to walk around that house. And then Officer Phillips, as Mr. Baker and Officer Phillips are exiting the home, Officer Phillips shouts, 2 coming out. He testified that the reason he did that is because he didn't want to get shot. He wanted everyone to know where he was, because people weren't walking around that shouldn't have been walking around, and he didn't want anyone to mistake him for someone that shouldn't have been there and shoot him. And he didn't want anybody to shoot Mr. Baker either. And then Mr. Baker is escorted back up to the police cars that are there on Highway 81. And Officer Phillips testified that Mr. Baker asked if he could go stand by his family. At that point, Mr. Baker is still in handcuffs, and Mr. Baker knows that he has to ask those officers for permission for where he can stand and who he can stand next to. And this is Officer Phillips' testimony about exactly when he handcuffed and unhandcuffed Mr. Baker. What we saw from the video, he kind of clarified this, is that he unhandcuffed him as they were walking up, and then re-handcuffed him before he exited the house. At all times, Officer Phillips was with Mr. Baker as Mr. Baker was taken back into the house to secure the family dog. And then, as he said, he put Mr. Baker back in handcuffs. So what does it look like inside that home as Mr. Baker is there trying to get to the dog? Well, what we see here, Judge, and this is timestamp 10/17/16 from that video, we see Mr. Baker, and we see multiple police officers here with shields and rifles, and then a few minutes later, Officer Phillips turns so we can see some more of the officers that are here, and there's, at this point, some officers in the garage, and we got 2 more here, all with AR-15 rifles. And then as soon as Mr. Baker puts his dog into the laundry room, he puts his hands up. Because there are a lot of officers in a very small space, all with very powerful weapons. And then Mr. Baker is taken back up to, as I said, Highway 81 with these where the other police cars are, and other people would be in hell. So this isn't a situation where once they get out of the house, Mr. Baker can go stand where he wants to go stand. Mr. Baker asks who he can stand next to. And Officer Phillips escorts him to a very specific place up here on Highway 81. And we don't have an exact time to the minute of when the handcuffs are removed. But we know that Mr. Baker and all of the others were in handcuffs at least up until Officer Phillips' videos end, which is around 10:22 in the morning. So for at the very least for 22 minutes, they are in handcuffs, all surrounded by armed police officers. The CAD report is consistent with that and advises that the roadway is opened back up around 10:22. But, and the best I can discern, the state's argument is once those handcuffs come off, everyone is now no longer detained. They can walk where they want to walk. They can do what they want to do. Everyone's free to go, and no reasonable person would feel that they were being detained. But that's not exactly what happened, because the psychological impact of that detention is going to continue, because it was a lengthy detention. It was 22 minutes at least. There were a large number of police officers, all with firearms, and there are police cars all up and down Highway 81 and all in that driveway. No one, and every officer testified to this, no one ever informed any of the individuals that were in that driveway, and especially Mr. Baker, no one told him he was free to go. No one told him that he didn't have to talk to anyone. And when we listen to the audio recording of the conversation, the interview, and the interrogation between Detective Lacroix and Mr. Baker, at the very end of it, what does Detective Lacroix say? He says, yeah, you can go back up there. At that point, Mr. Baker is unhandcuffed, and Detective Lacroix is still telling Mr. Baker where he's allowed to stand and where he's not allowed to stand. And Mr. Baker knows that he can't walk wherever he wants to because he doesn't want the 15 to 20 police officers to think he's resisting arrest or failing to comply with any of their commands. He knows that he has to stand only in the places where they tell him that he's allowed to stand. Same thing happens with Ms. Head. During the conversation with Ms. Lanier, you can hear her ask for permission to go into her own vehicle. She knows that she can't just do that. She asks Detective Lacroix whether or not that can happen. And he gives her permission. And at the end of it, he again tells her where it is that she's allowed to go stand. Yeah, you can go ahead and stand over there. The state has elicited testimony and made the argument that people were milling around, and that's just not true, Judge. Their own statements contradict that. Every one of those people that we hear talk, they're talking about asking for permission from the cops for where they can walk, where they can stand, who they can talk to. And it's Detective Lacroix that directs that Ms. Head, Ms. Knight, and Mr. Williams are transported to HQ. It is Detective Lacroix, it is law enforcement that's saying where these people can go and where they can't go. Now, here, again, this is a bit where the testimony is that everybody can kind of mill about. Everyone just kind of standing together. Nobody had left. And you didn't tell anybody that you should leave. This is Officer Phillips' testimony. Well, this is what that looks like, Judge. This looks like Miss Head crying and to the point where she couldn't even drive. That's what it being calm looks like. That's what somebody without a gun, without a bulletproof vest, without a shield, without a cop car with lights and sirens, that's what a reasonable person in that situation that morning felt about how this looks. And she is crying, she is upset, she is not handcuffed, and we are looking at 10:29:51, 30 minutes after that initial detention. She is clearly distraught, and this is what a reasonable person. We had officers testify, oh, everybody was calm. Yeah, the officers were calm. They had AR-15s. They had bulletproof vests. This is what a civilian, a person who had been held at gunpoint, this is how they reacted. This is the reasonable person that the court should be looking at. This is how a reasonable person perceived that situation. And this is after the highway had opened up, and you can see that there are still cop cars along the highway, even though traffic's traveling. So now at this point, we have constricted the area in which people can move. Now people are only able to move about in that driveway, yeah, you know what? Somebody could walk out into the traffic if they wanted to. Nobody's going to. Nobody's going to walk out on the Highway 81 in the middle of that traffic. The only reasonable place for anybody to walk around is in that driveway. Nobody here is milling around. This is what it looks like, Judge. Nobody's milling around. There are 4 police officers at the edge of the driveway. There are 4 police officers around Mr. Baker. There are 3 more up by the house. This is a massive police presence still. All in a very small area, all within someone's driveway. And if Mr. Baker were to walk away, at this point he's going to walk past either Detective Lacroix or these other 3 detectives, then walk past the 4 officers at the edge of the driveway, one of whom is in a bulletproof vest, and then walk out on the Highway 81 away from his home. So if Mr. Baker wants to end these interviews, he wants to not talk to these officers, he's either got to kick them out of his home, which isn't happening, or he's got to walk past all of these officers and out onto the highway. A reasonable person standing where Mr. Baker is standing in between 2 cop cars surrounded by police officers is not going to feel that they are free to walk away from that situation. Now, Detective Lacroix said he was asked whether or not there were officers behind Mr. Baker's back. He said no. Judge, that's just not true. There are 3 officers directly behind Mr. Baker. Just right there in the video, 3 officers. You know what? Do I think Detective Lacroix was intending to deceive the court? No. But what he said wasn't true. There were, in fact, 3 officers, 3 detectives, all with firearms, at Mr. Baker's back. And this picture here, Judge, is important because this shows, because this is around the time and the general scene where Mr. Baker is talking to Detective Lacroix. I do not know if this is the exact moment that that audio was taken, but it's around that time. The scene is not terribly different. And he is between 2 police cars with 4 officers around him. And again, the court can make a determination about whether or not a reasonable person in Mr. Baker's situation here would feel that he was free to walk away from all of those police officers, away from his own home, in order to end this interview. Here's yet another picture of what that looks like. And here it looks like we're starting to get some of the cars leaving, but we still see them on the highway. We still see the number of police officers that are there. And again, now one of the cars has left the driveway, but we can now see how many officers are right there in the driveway. So Detective Lacroix said when he got there, was anyone in handcuffs? No. Was anyone being detained? No. He said he didn't know. Nobody told him that any of the individuals that he was supposed to be talking to were detained. Again, that's just not true. Right here, here's Detective Lacroix himself walking right past Mr. Baker, who's also in the scene. At this point, Mr. Baker is wearing handcuffs and he's sitting on a cop car. Detective Lacroix walked right past him. Here's another picture. Here's Detective Lacroix looking back at Brooke Knight. She's wearing handcuffs, standing between police cars. Again, do I think that Detective Lacroix intentionally misled this court? No. But was it true that he never saw anybody in handcuffs? Or that nobody told him? I don't think that that's true. He walked past 2 of them. And then what we have here is Detective Lacroix standing at the front porch of the house as Matt Baker is escorted in to go secure his dog, escorted by a police officer. Judge, I'm going to play, I believe I'm going to be able to play just a small portion of this video, audio here. I apologize, Judge. It doesn't look like that's going to work, but I can tell you the part that the timestamp and the part that I would like for the court to take a look at, or take the court to listen. I would like the court to listen to. And it is about 4:53, and this is the interview between Detective Lacroix and Mr. Baker. And at the very end, you can hear Detective Lacroix say, "Yeah, you can go back up there, man." Those are his exact words. And he says them to Mr. Baker. And this is after the state has said that Mr. Baker's free to go. And we've got Detective Lacroix telling him where he can stand, where it's okay for him to go. important, the exact words that Detective Lacroix uses when he's talking to Mr. Baker about coming to the police station. He doesn't ask, can you come? Do you want to come to the police station? Is that okay if you? No. What he says is, and he says that it's a request, but he says, I need you to come to the police station. Now, Judge, I'll also point out is that when we listen to the audio, at no point do we ever hear Detective Lacroix ask the question, do you want to come to the police station? We don't even hear him say, I need you to come to the police station. What we hear is him talking to Miss Lanier, planning for Mr. Baker to already be at the station, right? This isn't a, hey, you know, if Mr. Baker wants to come to the police station, how do we make that happen? He says, I need to talk to him. In his own report, he says, I need you to come. He says, I need you to come to the station. That's what he writes in his report. Now, he's going to testify here that it was a request, but for example, if my boss says, Christine, I need you to call me, or Christine, I need you to come into the office, that's not a question. That's not a request. I need to do it. And my boss doesn't have a gun that he wears. And so what we have here is somebody with a firearm with the power to arrest Mr. Baker saying, I need you to do this. That's not a request, Judge. And he says, well, Mr. Baker's surrounded by other law enforcement. Again, Judge, you can take a look at the CAD report's going to give you some time frames about when Mr. Baker gets to the police station. After the driveway interview, that's about 11:17 a.m. And then Officer Padgett testifies about how he hands it off, essentially, to another police officer. And Officer Padgett again testifies about, it was Officer Reed, and that he was giving him Detective Reed so that we can make sure that somebody interviews Mr. Baker. We had Ms. Green testify today that she took photographs, fingerprints, and a gunshot residue from Mr. Baker. Now, I understand the state's going to argue, oh, well, that's just something that they do with witnesses, and they do that with everybody. Well, if you ask a person on the street, what does it look like to get arrested? It looks like going to the police station, being photographed, and fingerprinted. And that's exactly what happened to Mr. Baker. And Ms. Green talked about how she couldn't remember one way or the other, whether or not she told Mr. Baker, oh, hey, you're not under arrest, this is just routine. She could testify that she remembered, it might have been part of her routine, but she doesn't remember whether she said that to Mr. Baker. And she did that with Mr. Kosky, who was clearly a suspect, and the other four, and we should note that all 5 of them were in fact arrested in this case. So the fact that she doesn't recall that, and the fact that she said it to Kosky too, they were all arrested. There's nothing about that that a reasonable person would say, oh, hey, I'm not in trouble, I'm not being detained, it's just somebody taking my prints. That's just not an argument that has a lot of credibility, Judge. Detective Lacroix here is talking about how Mr. Baker was kept separate from everybody while we're waiting for this interview. And the interview with Mr. Baker begins about 2:45 p.m. And he has, at that point, been under constant supervision by a police officer, and we can almost from a chain of custody talk about exactly which officer was standing next to Mr. Baker from about 9:52 in the morning when Officer Frigoli is following the car to being handcuffed and Officer Phillips being with him. We can almost map out which officer is standing next to Mr. Baker all the way up until 2:45 about p.m. when that interview begins. And Judge, I'd encourage you to watch the entirety of this interview because the actual conversation with Mr. Baker is about 30 minutes. During that, Detective Lacroix never asks Mr. Baker if he wants to talk to him, never reads him Miranda Rights, never tells him that he's free to go. Despite Mr. Kosky having implicated Mr. Baker as an accomplice in a quadruple homicide, Detective Lacroix says, at this moment, I'm not charging you with anything. Mr. Baker is in fact locked in that room at one point in order for him to use the restroom. And during this whole day, if he wanted to And Mr. Baker, and pardon my phrasing of this, Judge, but Mr. Baker couldn't even take a piss without having an officer escort him somewhere. That is the situation that Mr. Baker was in that day. He had to ask to go use the bathroom. He tries the door twice to find it, that it's locked. And it isn't until 1857, almost 9 full hours after being held at gunpoint, that he's formally arrested. And then, and Judge, I want to talk about why, and I'm almost done, Judge. I want to talk about why this press release is important. One, this is what Detective Lacroix says to the public. This is what he wants the community to know. And he wants the community to know that by 1000 hours, these individuals were detained. And this whole discussion from the police officers about whether someone's a suspect or a witness or detained, those are law enforcement created classifications. They are distinctions without a difference. To Mr. Baker, it doesn't matter whether he's classified as a witness, a suspect, or whatever. What matters to Mr. Baker is that he was held at gunpoint, handcuffed, escorted to the police station in a police car. He was photographed, fingerprinted, gunshot residue. He just sat in a room until an officer brought him into a room and interrogated him. He was never away from a police officer during any of that time. That's what matters. It doesn't matter whether Detective Lacroix thought that he was a suspect or detained or whatever. What matters is what Mr. Baker went through. And this is what Detective Lacroix is saying to the public, is that even though he's going to get on the stand and say he wasn't detained, he's going to tell the public that Mr. Baker was detained. And so, Judge, the rest of this is what I can put in the brief, but these are reasons why the driveway interrogation shouldn't be, I admit, obviously, no Miranda warnings, and the massive police presence would have led a reasonable person to believe that they were not free to walk away from that situation and end that interview. And there is no change in any circumstance, no change in the way any of these officers interacted with Mr. Baker as they were taking him to the police station. If anything, the custodial nature of it gets worse. Now he's in the police station. Now he's in a police car. And so the police station interrogation, is even more custodial than the driveway interrogation because of everything that Mr. Baker had been going through for so many hours at this point. And Judge, the last thing that I will say is, I would like for the court to take a look at what do the police do and what do they say and what do they not say. They never tell him that he's free to go. They never tell him that he's not under arrest, but they do tell him to get on the ground. They do tell him to stand over here. They do tell him they need to talk with him. Those things are all important. And the last point, Judge, is this written statement that Mr. Baker writes. Regardless of the court's determination on the driveway statement and the police interrogation, this written statement is distinguishable from those. And it is distinguishable because Mr. Baker is actually detained. When he is handed that form, that door is locked. Doesn't matter whether Mr. Baker knows it or not, he is actually detained. He is actually cannot walk. It is undisputed. He cannot walk away. That door is locked. And he has not been read his Miranda Rights. So even if the court feels like the massive police presence and everything that Mr. Baker went through wasn't, that a reasonable person would have felt that they were free to go, as Mr. Baker is writing that statement, he is in fact and actually not free to go. So that statement, at a minimum, should be suppressed because of, as I said, the fact that he's not actually free to go. And Judge, the rest of it, the law, I'll reiterate that in our briefing, and I can supply the court with pretty extensive case law on what these considerations are, and apply them to these fairly unique facts that we have here. And Judge, so we will be asking you to suppress all of the statements that Mr. Baker made, including the written one. Thank you, Judge.
Thank you. Mistake.
Judge, Your Honor, I'll do my best to keep this brief, knowing that we're going to write a brief. So I will just kind of hit the high points.
All right.
You're aware of the facts. You'll see the videos. You'll hear the videos. You'll hear the audios. You've been here this whole time, so you know what was said, what was done. The problem is that the defense wants to substitute the initial police response for the defendant being in custody. And that is a huge problem because he was not, during the time that he spoke to Detective Lacroix, at both the driveway and at the police department, he was not in custody. He was, however, briefly detained. As you saw, as you heard from each of these officers, they were detained, and then for lack of a legitimate term, I don't know what to call it, they were all undetained. They were all cuffed, they were put on the ground, cuffed, escorted away from the residence, out of the driveway to a safe location while police were looking for Jacob Koski in the house. Once they found out that Jacob Koski was not in the house, everyone was unhandcuffed, and the defense says, oh, the state wants to say they were just milling about. They were milling about. You can see them in the driveway. You can see Matthew Baker's mother, who had been in the street, now she's up at the top of the driveway. You can see that Brooke Knight, who had been in the street, is now up at the top of the driveway. Everybody's just hanging out. Everybody's talking to officers, talking to each other, doing whatever. The problem is that he was not in custody. So Miranda does not apply. With regards to detention, I have, and I will put them all in the brief, but as Your Honor, you've been doing this a very long time. You know that someone being detained does not trigger Miranda. It is a non-custodial statement. At that point, there is case law out there, and I'll again put that all in the brief, but where someone was handcuffed and transported to a police department in handcuffs, and then where the handcuffs were later removed, they were told that he was not under arrest, and that equals not in custody. Here, we have a defendant who is detained, wearing cuffs, and then the cuffs are later removed. He was freely talking to the detective. He was asked if he would come to the police department. He came to the police department, and he was still not in custody. And even at the very beginning of when Detective Lacroix comes in to talk to him, he said, "You're not under arrest or anything." And his exact words in the defense, if you recall, in the motion, they tried to paint it as, you said you weren't under arrest yet. That's not what he said. He didn't say, you're not under arrest yet. What he told him is, you're not charged with anything at the moment. I'm just trying to get information. So what the defense tried to make it sound like is from the very beginning, he said, you're not under arrest yet. And that is absolutely not what the detective said. So there was nothing in that other than him telling him, you're not under arrest. You're not charged with anything. But the defense wanted to make it clear to the court, or try to make it clear to the court, that of course Matthew Baker would have assumed that that meant he was going to be arrested, because the defense tried to put the words "yet" in your mouth, in the detective's mouth, and that's not at all what happened. Again, Your Honor, case law, case after case, talks about that detention is not require a need for Miranda, even temporary detention. It just does not trigger Miranda, so there's none necessary. There are situations where in murder cases where defendants have given several interviews. The first interview, they were not in custody, they were not Mirandized, and then later they did a second interview, they Mirandized him, and then they arrested him at the end of that. And the courts say that that's okay. There are other cases out there, Georgia Supreme Court, where they talk about a defendant being brought to the Criminal Investigation Division, the Detective Division, in cuffs, in a police car, that the officers had gone to his house in the early morning hours. They talk about, in that case, the detective asked the defendant during his interview with him, hey, are you going to class tomorrow? And talked about things in the future. And the court said that indicates that obviously he wasn't talking about arresting him. We have here with Matthew Baker, we have Detective Lacroix and Matthew Baker talking about Matthew Baker when he's out and about. Once he gets away from there, Jacob Koski is still in jail. Detective Lacroix is trying to assure him, I can't promise you anything, but he's not going to likely be bonding out on these charges, and you'll hear that in the interview. And they're talking as if the direction of the conversation is when you get out of here, when you leave the police department and you go home, we'll do what we can to keep you safe. We'll have officers drive by, things of that nature. So again, talking about the future of him not being in custody. And that's very clear with Detective Lacroix, both in his statements at the driveway, where he was telling Mr. Baker and his mother that he would make sure that they got back there. And the situation obviously changed. Detective Lacroix at that time, if Your Honor recalls, he had not spoken to Jacob Koski. He didn't have all of the information. He hadn't yet talked to Matthew Baker. And it wasn't until Matthew Baker himself put himself in the house and said the things that he said to Detective Lacroix that then a decision was made after that to place him into custody and place him under arrest. Other cases, Your Honor, talk about that it is a non-custodial statement and no need for Miranda when there are no cuffs, when the person is not under arrest, and when they agree to come in for a statement. Other cases talk about a defendant being transported to the police department by a law enforcement officer and even patted down there. And the court said that even if that person was a suspect, that does not necessarily mean he's in custody. That's not the only thing. It's not about the subjective belief of the officer. It's not about the subjective belief of the defendant. It is what a reasonable person objectively believed that they were in custody. You can clearly see here at the driveway statement where Detective Lacroix was speaking to Angelina Lanier, to the defendant's mother, talking to her, and you can hear Matthew Baker interjecting himself. Now, what's important there is at some point, the defense wants to say that Detective Lacroix gave him permission or told him, ordered him where he had to stand. If you listen to it, you'll hear him be like, no, it's okay, you can go over there, doing whatever. And then Matthew Baker, after he did ask, apparently, can he go there, Detective Lacroix says, I'm just going to go up there and speak to her. And he goes up to speak to Miss Lanier, and obviously Matthew Baker walked over to them because Miss Lanier was standing separately from where Mr. Baker was. So it's very clear that he felt free to move about, to talk. The defense wants to put into the court's mind that the police force and the police presence, all of a sudden that means that he's in custody, needs Miranda, and the case law is very clear on that. It's not just about that. It's not, you can have a large police presence and a person doesn't reasonably believe that they're in custody, particularly after they've been unhandcuffed and allowed to walk about. So I would ask the court to keep all of that in mind. And of course, Judge, I'll cite all of these cases in the brief. There are cases out there, Judge, that specifically address a locked interview room. And with regards to locked interview rooms, it comes down to, did he know that the door was locked? And it's very clear that he didn't. You'll see, and you've seen on the video, that at that point, he just got up and went to go open the door. Now, had he known that that interview room was locked, he wouldn't have tried the door handle, reason would stand. He tries it, and not only tries it then, but he tries it a second time. So at the time that he was speaking to Detective Lacroix, he's there near the door is not locked, detective does not have his firearm on, he's sitting away from the door, Matthew Baker is the one closest to the door, and defense counsel once again tried to show on the video going left to right. So it's you, it's Matthew Baker, then you, then the door, as if implying for the record that Detective Lacroix was somehow between Matthew Baker and the door. And it's clear from the video, he is not. He's nowhere near the door. Matthew Baker had a direct line. He never asked to leave. He never said he didn't want to talk to the detective. He never gave any indication that he was unwilling to talk to the detective. And the detective did not give him any indication that he had to talk to him, that he couldn't leave. Defense wants you to use Cale ahead as the reasonable person standard. I'll address this in the brief as well, Your Honor, but there is nothing reasonable about Cale ahead, who later goes to the police and lies It starts lying here at the scene, but then later lies to police about who was where, who did what. She is obviously hysterically crying because she is the one that is telling officers, I drove the car to a murder. I drove the car to a murder. I promise you I had nothing to do with this. My dad was murdered. She's crying out. That has nothing to do with the police presence. There's nothing to indicate that she is crying. The officer is clearly trying to calm her down. Officer Phillips is talking to her. That is not the reasonable person standard. A young lady crying at the scene as she's relaying to the officers that she drove the vehicle to a murder scene. She drove somehow and was somehow connected to that. That has nothing to do with the police presence, with whether or not she believed that she was in custody. Obviously, she's not cuffed. She's having a cigarette. She's trying, officers trying to calm her down. Do you need me to call you an ambulance? That is not the reasonable person standard. The reasonable person standard would be after these folks have been released from handcuffs and they are out and about and walking around on the property, talking to each other, talking to police. I don't want to say hanging out because I don't want to minimize that there's still an investigation going on, but none of them reasonably should believe at that point that they were in custody. If you want to go with a reasonable person standard, Miss Lanier was clearly talking to Detective Lacroix. She's talking to him about her complaints about other officers, about another officer that she felt was rude to her. You can hear that in the interview. I would submit to the court that after they were unhandcuffed, after everybody was free to move about, they were no longer detained. He was not at any point in formal custody up until the very end when the sheriff's office deputy came in and physically placed him under arrest. And that is when he, at that point, was clearly under arrest. With regards to his written statement, defense wants you to believe that because the door was locked, therefore he was detained. But he didn't know the door was locked. And so he wrote that statement at a time that he had it's clear from the video, he had no idea the door was locked by that point. So, Your Honor, the evidence is clear that yes, initially detained, but no, police force, police involvement, their response to this scene does not indicate in custody. And it doesn't negate the fact that they were unhandcuffed. Everybody was walking about, freely talking, freely moving. Mr. Baker was interjecting himself in a conversation that had nothing to do with him. The defense wants you to believe that he was so scared and so intimidated by the police, but the audio belies that fact. And if you recall from the initial hearing, defense did not want the court to hear that because it shows that he is out and about and milling around and inserting himself in a conversation. There is no way he believes he's in custody. And that is just moments after he just talked to the detective. So with all of that, Your Honor, I'll put all the case law in a brief. I'll put all these facts in a brief and I'll present that to the court. But the state would ask that you deny the defense motion to suppress Mr. Baker's statements. And I'll brief all of that for you later.
All right. Thank you very much. Conclude today's activities. Recent due December 6th by 5 p.m. And any documents you got as far as submitted in the hearing, I'll be copied whenever you can get around to it. It's not for a meeting. But, thank you very much.